Question 571. When a married couple, both persons under 18 years old, make a real estate contract, it is considered A. Valid, B. Void, C. Valid once at least one of the spouses turns 18, D. Non-enforceable. Correct answer is A. Valid. According to California law, married persons under the age of 18 are considered emancipated minors. Emancipated minors have the same legal capacity to enter into contracts as adults, and they cannot later disaffirm those contracts simply because they were under 18 at the time of signing. Therefore, when a married couple, both persons under 18 years old, make a real estate contract in California, it is considered valid. Question 572. Nancy signs an apartment rental lease which contain a covenant against assignment of the lease without consent of the lessor, Lenny the landlord. Nevertheless, Nancy assigns the lease to a friend without gaining Lenny's consent. The assignment is A. Void, B. Voidable, C. Illegal, D. Unlawful, punishable by a civil fine against Nancy, the would-be assigner. Correct answer is B. Voidable. A covenant against assignment in a lease means that the tenant, Nancy, is prohibited from transferring their leasehold interest to another party, her friend, without the landlord's, Lenny's, permission. However, if Nancy proceeds with the assignment without Lenny's consent, the assignment is generally not automatically void. Instead, it is voidable at the option of the landlord, Lenny. Lenny has the right to take action to terminate the lease with Nancy because she violated a covenant in the lease agreement. Lenny could pursue legal action for breach of contract. The assignment is effective between Nancy and her friend unless and until Lenny takes steps to void it. Nancy has effectively transferred her rights and obligations, to the extent the law allows in an unapproved assignment, to her friend. Lenny can choose to accept the assignment. If Lenny acknowledges the friend as the new tenant, e.g., by accepting rent directly from the friend, he may waive his right to void the assignment. Question 573. A solemn formal declaration by a person under the penalty of perjury that her statements are true is called a A. Affirmation, B. Affidavit, C. Declaration, D. Announcement. Correct answer is A. Affirmation. An affirmation is a solemn and formal declaration that something is true, made by a person who conscientiously objects to taking an oath. Legally, an affirmation carries the same weight and has the same binding effect as an oath. By affirming, the person is declaring the truthfulness of their statement and acknowledges that they are subject to the penalty of perjury if they lie. In essence, it's a way for individuals to formally and truthfully state something without using the traditional language associated with swearing an oath, often for religious or personal reasons. Affirmations are commonly used in legal proceedings, when signing official documents, or in any situation where an oath would typically be required. Question 574. When a broker balances his trust account with his bank statement, it is called A. Restitution, B. Reconciliation, C. Balancing action, D. Clearance. Correct answer is B. Reconciliation. Restitution refers to the act of returning something to its rightful owner, often used in the context of resolving a breach of contract. Balancing action is a general term and doesn't specifically refer to the process of comparing a bank statement with account records. Clearance can involve settling financial obligations. It's not the specific term used for the process of balancing a trust account. Reconciling a trust account involves comparing the records maintained by the broker, checkbook register, with the official bank statement to ensure all transactions are recorded accurately and there are no discrepancies. It's a crucial process for financial accountability and identifying potential errors. The BRE states that brokers should reconcile their cash record with bank statements on a monthly basis, keeping a separate record for each beneficiary transaction. Question 575. A broker's classified advertisement for a home he has a listing for includes the following information: 3-bedroom, 2-bathroom home, fireplace, patio, hot tub. Price is $350,000. Call 555-385-8764. This is an example of a display ad, B. blind ad, C. specific ad, D. California Realtors Association ad. Correct answer is B. blind ad. A blind ad is a real estate advertisement that fails to identify the broker or the brokerage firm responsible for the advertisement. In California, real estate advertising regulations require brokers to clearly identify themselves or their brokerage in any advertising of listed properties. The advertisement you described includes specific details about the property and the price, along with a phone number to call. However, it does not mention the name of the real estate broker or brokerage firm. This omission makes it a blind ad, which is generally prohibited in California to ensure transparency and accountability in real estate advertising. Question 576. Ms. Adams made a deposit on the purchase of a property. During the escrow, the seller learned of a highway rerouting which would greatly enhance the value of her property. She instructed the broker to return the deposit to the buyer. Ms. Adams refused to accept the deposit. Her most unlikely course of action would now be: A. to pursue a lawsuit for specific performance from the seller, B. unilateral rescission, C. to file a claim for monetary damages, D. to accept a settlement. Correct answer is B. unilateral rescission. Ms. Adams has a valid contract and the seller is breaching it. Specific performance is a legal remedy where the court orders the seller to proceed with the sale as agreed. This is a very likely action for a buyer who wants the property, especially when its value has increased. Even if Ms. Adams doesn't want to force the sale, she has likely incurred costs, inspections, appraisals, time, due to the contract. She could sue the seller for monetary damages to compensate her for these losses resulting from the seller's breach. Litigation can be costly and time-consuming. It's quite possible that Ms. Adams and the seller could negotiate a settlement, perhaps involving the seller paying Ms. Adams some amount of money to release her from the contract. The most unlikely course of action for Ms. Adams would be unilateral rescission. Unilateral rescission means one party decides to terminate the contract without the agreement of the other party and without legal grounds, like fraud or misrepresentation. In this scenario, Ms. Adams has a valid purchase agreement and the seller is attempting to back out due to a change in circumstances that benefits the seller. Ms. Adams has no legal basis to unilaterally rescind the contract. In fact, she wants to proceed with it. To rescind unilaterally, give in, with nothing in return from the seller, would not gain her anything. Question 577. Which of these real estate transactions are exempt from the disclosure requirements in the California Civil Code that apply to conveyances of 1-4-unit dwellings? A new home sold in a subdivision where a public report is not required, B. foreclosure sales, C. transfers from one spouse to the other, D. all of the above. Correct answer is D. all of the above. Based on California Civil Code, the following real estate transactions are exempt from the standard disclosure requirements that apply to conveyances of 1-4-unit dwellings, primarily the Transfer Disclosure Statement (TDS). 1. Transfers pursuant to court order. This includes probate sales, sales by a bankruptcy trustee, etc. 2. Foreclosure sales. This includes a deed in lieu of foreclosure and a transfer by a beneficiary who has acquired the property by foreclosure or deed in lieu of foreclosure. 3. Transfers from one co-owner to one or more other co-owners. 4. Transfers made to a spouse, or to a child, grandchild, parent, grandparent, or other direct ancestor or descendant. 5. transfers between spouses in connection with a dissolution of marriage or similar proceeding. 6. Transfers by the state controller pursuant to the unclaimed property law. 7. Transfers as a result of failure to pay property taxes. 8. Transfers or exchanges to or from any government entity. 9. New homes sold in a subdivision where a public report is required under Business and Professions Code Section 11018.1. These have their own disclosure requirements. However, new homes in smaller subdivisions where a public report is not required might still be exempt from the TDS. 10. Transfers of a leasehold interest exceeding 1 year, though disclosures might still be practically advisable. It's important to note that even in exempt transactions, sellers, if they have knowledge, still have a common law duty to disclose known material defects that could affect the property's value or desirability. The exemptions primarily relate to the specific statutory requirements of the transfer disclosure statement. Question 578. During escrow, if the escrow instructions are in conflict with the deposit receipt, then the A. Escrow instructions are to be followed. B. Deposit receipt is to be followed. C. Seller can withdraw his offer. D. A new agreement between the parties must be executed. Correct answer is A. Escrow instructions are to be followed. Escrow instructions are the specific, binding directions given by the buyer and seller to the escrow agent outlining the procedures and conditions for closing the transaction. They are typically drafted after the deposit receipt, purchase agreement, and are intended to provide the detailed steps for carrying out the terms agreed upon in the deposit receipt. The deposit receipt, purchase agreement, is the initial contract between the buyer and seller that outlines the fundamental terms of the sale, such as the price, financing, and closing date. If a conflict arises between the deposit receipt and the later escrow instructions, the escrow instructions, being the more recent and specific directions to the escrow agent, generally take precedence. This is because they represent the parties' updated and more detailed agreement on how the transaction should proceed through escrow. The seller cannot unilaterally withdraw their offer simply because there's a conflict between the two documents. The existence of a conflict usually necessitates a resolution based on the later agreement, escrow instructions. However, if the conflict is significant and prevents clear execution of the transaction, the escrow agent might require further clarification or a new agreement between the parties. Question 579. Principals face personal liability to creditors in a limited partnership, B. Partnership, C. Corporation, D. None of the above. Correct answer is B. Partnership. In a limited partnership, LP, general partners usually bear personal liability for the partnership's debts. Limited partners, however, typically have their liability capped at their investment amount, as long as they don't actively manage the business. This structure offers some partners liability protection while others retain management responsibilities and associated risks. A corporation is a separate legal entity from its owners, shareholders. This separation generally shields the shareholders from the corporation's debts and liabilities. The corporation itself is liable for its obligations. This is the concept of limited liability. Partnership. In a general partnership, each partner is personally liable for all the debts and obligations of the partnership. This means that if the partnership cannot pay its creditors, the personal assets of the partners, like their homes, cars, and savings, can be at risk. This is known as joint and several liability. Question 580. The land description method that refers to the terms townships, sections, and ranges is A. Leaps and bounds method, B. Government survey method, C. Rectangular circumscribing method, D. Land analysis system. Correct answer is B. Government survey method. also known as the Rectangular Survey System or the Public Land Survey System, PLSS. This method was established in the United States to survey and divide land. It uses a grid system based on principal meridians, north-south lines, and baselines, east-west lines. Townships are 6-mile by 6-mile squares, and each township is further divided into 36 1-square-mile sections. Ranges indicate the distance east or west of a principal meridian, while townships indicate the distance north or south of a baseline.